हेलो हेलो आ रही है।
Shefford very rightly said, the most important thing about intellectual property versus creative expression is that copyright law was created not to stifle creativity but to encourage it. With these words in my mind, I would take honor to introduce our next expert and a phenomenal Dr. Kirti Jain is working as an assistant professor, Department of Pharmaceuticals, NIFER, Raebareli. She earned her M. Pharma and doctorate degree from Department of Pharmaceutical Sciences, Dr. H.S. Gaur, Central University, Sagar. Ma'am did her postdoctorate from MS University of Vadodara as Third National Postdoctoral Fellow. Dr. Jain holds 15 years of research experience on nanomedicine based drug delivery system and has been awarded with prestigious ICMR Shakuntala Amir Chandra Prize for the year 2019. Author of 5 books and more than 100 international manuscripts in peer reviewed high impact journals, Ma'am has contributed 7 modules for the subject Nanobiotechnology for EPG Pathshala program of MHRD UGC. Nominated for Renbeck Research Scholar Award 2012 and BioAsia Innovation Award 2015, Dr. Jain has been enlisted among the world's top 2% scientists consecutively since its inception in 2020 to 2024 in the field of pharmacology and pharmacy, a list created by Stanford University, USA. Ma'am, I kindly request your presence on the stage. Please welcome this genius mind with a huge round of applause, everyone.
Sexy. Hello. Okay, so good afternoon, everyone. So thank you for nice introduction and हाँ better रहेगा. Okay, so this workshop is regarding IP and IPR, and in this presentation, I will majorly focus on although the title is like IP, IPR, and mechanisms for IP protection. So intellectual property. What are the rights related to intellectual property rights, and then how we can protect the different intellectual property. Generally, when we discuss intellectual property, we have only one thing in mind like patent. But apart from patent, there are also other intellectual properties are there that you can protect and you can also gain the benefit of the same. So I will take a brief about this, as well as before in the start of the presentation I would like to tell you something regarding the trade related aspects of the intellectual property rights, in which I will cover what is like World Trade Organization. And before start of the World Trade Organization there was gate. So a brief introduction will be there regarding gates, then what are the agreements that governs the international trade in the services as well as in the intellectual property rights, which include one of the important treaty that is known as TRIPS. So that I will cover in brief, and then I will discuss about the what is intellectual property rights, and benefits of intellectual property rights, and finally we'll discuss about how we can file the patents. So I think this will give you some more insights regarding the intellectual property. So starting with trade related aspects of the intellectual property rights. Uh, the first thing is GATE, that is General Agreement in Trade and Tariff and Trade. So before start right now, if you see in the current scenario, all the trade related aspects of the international, there is like this world is changing right now a lot. We have like communication technologies, we have so much advancement in technology. Right now we can work from here, from India, from a particular place, and we can work it for like for all over the world. There we have like so many consultancy services. We have there are person who are working for like US from India itself, and we also gaining the advancement of this advantage of technology. We there are fields where people are enjoying the work from home. So this gate is was started like there was world war. We know there have been like two world war, one and two, and this world war has divided the international community into different parts, and there was lot of destruction has happened, but the gate was started to start the harmony in the international trade and tariff. And right now we can understand that how much this international harmony is important. If there is any war, is there is any movement or anything that can disturb the peace, we can see it. First of all, the first effect that we see on the trade, and that affects. Right now it's not like if some war is occurring in between two countries and it will affect those two countries only. No, there are high chance that will affect the other countries of the world, or maybe sometimes the whole world. So considering this, there was like this agreement was started, that was named as like General Agreement on Trade and Tariffs. It was a legal agreement among the different countries, and the purpose was to promote the international trade by reducing or eliminating the trade barriers. Right now, you may be listening कि US, there is now the government of Donald Trump, and he said that there will be tariffs, and India is also like now is in a situation, and we are also like having a strong determination. We can also reply yes, if you are imposing tariffs, we are also ready to do so. So this was the objective of making this agreement to reduce these trade tariffs and barriers that can make a barrier in the international trade. So this was initiation. This was first, you can see in the third point, this was first discussed during the United Nations Conference on Trade and Employment. And they were negotiating on making the International Trade Organization. But this attempt was failed because US was not agreeing and some other countries was not agreeing. And then this gate become the one of the provisional entity for processing or for the international relationship regarding the trade. So this came into this remained effective before the existence of the World Trade Organization, which came into existence on 1st January 1995, and this was due to the agreement among the 123 nations in the Marrakech on April 15, 1994. So WTO is the successor to the GATE, and the current situation. So here you can see World Trade Organization. It is an intergovernmental organization which was established in 1st January 1995, and now this deals with all the relationship regarding the trade and tariffs in the international trade, and that includes also regarding the this intellectual property. Here you can see currently there are 166 members of this treaty, where you can see the green one is showing the member countries of this World Trade Organization, and the blue one is showing the countries belonging to European Union. And the headquarter of WTO is in Geneva, that is in Switzerland, and the day-to-day function of this WTO is taken care by the General Council, and this General Council has members from all the participating states. So now the next organization which is particularly relevant to the today's program, that is BIPO, that is World Intellectual Property Organization, and this organization was created to promote and protect intellectual property across the world by cooperating with the countries as well as the international organizations. And this started its operation in 1970, although the proposal for this BIPO was given in 1967 in a convention of United Nations, and it started its operation in 1970. And its mission is to just have a balanced and effective international IP system that can govern the innovation and the transfer of the technology among countries or different countries in the world. now how, because you may be knowing like I have started with GATE and then covered the WTO and WIPO. So what is the reason for this? GATE is regarding like trade and WIPO is for intellectual property. So here you can see these two organizations have mutual supportive relationship where they cooperate to implement the TRIPS agreement. TRIPS agreement deals with the intellectual property services, and the aim is to implement or to govern the intellectual property rights and having harmony among different countries. So what is TRIPS? This is agreement, and this is agreement on trade related aspects of the intellectual property rights. And this agreement was negotiated in the Uruguay round of WTO, and this came into the force in 1995 again with the World Trade Organization. And this deals with the how the intellectual property law can be emphasized or enforced in the different countries, and India is also participating member of this TRIPS agreement. So in there was one important uh, declaration, that is Doha declaration, that happened in 2001, that also included one important point regarding the to promote access to medicines for all, because IP, the challenge with IP is that when you are protecting something that is giving although it has its own advantage, but there is disadvantage that can lead to the increase in the cost. And if a medicine which could be life saving, since I am in pharmacy, so we deal mostly with the like medicine, and it is very important that medicines should be affordable and should be available to all. If it is many times it happens when there is a product which is patented, it has high cost. So this change was included just to make sure that medicines should be affordable and could be available to each and everyone. There are some other agreements also there which are not that much relevant to directly IPR, so I will just take them in very brief. That is TRIMS, that is trade related investment measures, that deals with the how there is investment among countries. You know nowadays like foreign investors can also invest the money. So these are the aspects that are governed by the TRIMS. Then TRIMS was for investment measures, TRIPS is for intellectual property services, and the GATES is for the trade in services. So this agreement deals with the trade in services among the participant members of the WTO. The next part of the presentation includes the intellectual property rights, and how we can protect this intellectual property. So intellectual property, what is like property? Here you can see like this hall is the property of BBAU, okay, or finally BBAU also belong to government. Intellectual property is something that is the creation of mind. If you are creating a music or some like lyrics, so how you can protect it? For that there is one mechanism is there, that is known as copyright. Okay, you can copyright it. You might have learned about one there was a song that was said to be that was like given credit to someone else, and it was by some singer, I forgot the name. Yeah, that was some song was there, and later on he showed the proof, and that was the importance of copyright. If you copyright something that is creative, artistic, that you can protect with the help of copyright. Okay, so this is the power of intellectual property, because it is the creation of mind. It is not something like if you have a pen, you know this belongs to you. Okay, you have a plot, you have a car, anything that belongs to you, that is something like material that you can show. But intellectual property is that involves the intellect that has been created by the intellect of mind. So here you can see that intellectual property that is arises from the human intellect, and it is the product of human creation. And generally this IP will include the terms like you can see here, that is patents, copyright, trademarks, industrial designs, geographical indications, layout design of integrated circuit. If you are designing like these are the design for integrated circuit, because nowadays whatever we are doing, we have mobiles, we have computers, we have laptops, smartphones, all this work on this circuit. That integrated chip is the integral part of that all these communication devices. Then there is last part, that is undisclosed information, where you don't want to disclose the information, you can protect it by the trade secrets. The next part, IP. So what is IPR? IP, intellectual property, is the creation of mind or product of human mind. Intellectual property rights are the legal rights that are provided you by the government to any person, maybe group, any industry, that protects the creation of mind or intellect that have some commercial value. Okay, so it must have some economic importance. And the importance you can see here, the IPR, although there are multiple importance, but three significant importance are given here, like that. In by this IPR, the person who has originally put his or their efforts, they can get rewarded with this. This also encourages innovation, because you will get the reward, you can protect your creation. So definitely it will promote you to do more and more innovations. And the last one, to make society prosper and progress, because we have so many communication technology today's, that is all because of this IPR. You must have learned about there is a case between the Apple and Samsung. So many things we learn, like there was like there was breach of some design was there. So this has been only possible because of this IPR. Next we will see what are the different mechanisms to protect the IPR. So that includes patents. Patents are for the innovation. If you have innovated something new discovery, that you can protect by the patents. Then copyrights, I already told you that something that is something artistic, that you can protect with the help of copyright. Trademarks you might have seen, there are certain trademarks for each entity. You can see if there is like any car, you know the trademark for Hyundai is there, Honda there is a different trademark. Similarly Apple, आपको पता है एप्पल अगर एक बाइट है तो समझ जाओ दैट इज for Apple, okay, or means that recognized. So trademark is any symbol that can help in identifying any organization or any product. Okay, geographical indication means something that is native to a particular place, that could be protected as geographical indication. Then industrial designs. So designs can be any industrial design that could have some industrial applicability, can be protected under industrial design. Integrated circuit, I have already told you that layout design, all these latest communication technology, information technology depends on this, and that can be protected under this mechanism. And the protection of undisclosed information, like one of the most common example for this, like Coca-Cola, the formula they have protected under the trade secret, and that can be renewed indefinitely. So next part is very important. What are the different rules and laws that govern the IPR or IP intellectual property in India? That includes Copyright Act is there, then Trademark Act is there, Geographical Indication of Goods Registration and Protection Act 1999, Geographical Indication of Good, that is in 2002, Design Act 2000 and Rules 2001, Semiconductors Integrated Circuit Layout Design Act 2000, and the rules in 2003, Biological Diversity Act 2002. So this is for biological diversity. You know that if you are using something from nature, many times it happens, you may have to take the permission or approval from the biological diversity according to this biological if you are using your that you want or that you want to market. Then Protection of Plant Varieties and Farmers' Right Act 2001 and Protection of Plant Varieties Rules and 3. So these are for the plant varieties that you can protect under this act. Importance, and then I will cover how you can file patent, what are the different parts, what are the procedures. There is what is provisional and complete specification that we will discuss in the next part. For there is economic importance. See, this gives you the legal right that will stop others creation. You might have like watched that movie Tarzan is a good example, like for a like very and that was used by someone else and there was like that. So this is the like then you learn about Tata Nano. It has, although it was not successful, but they have a lot of patents and design patents from this design. So this also gives the innovation. We have already discussed. There is also incentives for the same. If you are designing something, if you are as like your own, if you have your own business, and if you as an employer part of something that can also give you the incentives. Then this also encourages the investment in research and development because the research you will give you some new innovative value. So now we will come to some. So for that there is one of the important intellectual property mechanism, that is patent. And patent is the property like any other property that can be bought, that can be sold, that can be assigned or licensed. Okay, here the legal rights are granted by the government to the original inventor or researcher who can use it. And if you don't want to sell by yourself, you can also give license to someone else to sell it on behalf, and you can get the license. Patent is generally granted for an invention by a country to the inventor and for a limited period of time. As an this is not like you are getting it for lifetime. You will get it for a certain duration, and this all you are getting in exchange of disclosing all the information, because you are disclosing your invention. When you will file your application, by this application, while you are filing this application, it will be published in a certain duration, and then it will be available for others to read. So that further help in further development and advancement in a technology. And these are the three important criteria. If you want something that you think this could be an innovation and you want a patent for the same, then there are three important things that you have to take care, and you have to check that whether your invention is meeting these criteria or not. That criteria are nullness. Novelty means it should not be inventiveness, it should not be obvious, it should have some inventive step. And the third one is it should be useful, means it should have industrial applicability, some economic importance should be there. So in patents, I've already told you this is like exclusive rights are granted in this by the government. Patents are covered under the Patent Act 1970 and the rules 2003. And before 2003, patents were used to be granted only for process, but from the 2005, now they are also being granted for the product. And this rule change has been come with this patent rules 2003. And here the word is any patent, you will most of the time you may get question that may be related to inventive step, whether it is an invention or not. So for that they have given a specific requirement what could be considered as an invention. And for this there is in one section it has been mentioned, invention means a new product or process involving an inventive step and capable of industrial application. This inventive step is very important because if you are repeating something, that will not be inventive step. If you are mixing two things and you are getting third thing, that is not an inventive step. There should be some skill involved in the generation of any IP, then it only be considered as an invention. So we'll see these three criteria in a little detail here. That is, novelty means there should be no prior publications. If you don't have skill in that, you will say, oh, it's something new. But the person who can make it will say, oh, we can make nanoparticles. There are simple steps. There are two approaches that you can use, bottom up or top down approach. So that is not inventive for a person who is skilled in that art. So it should be inventive for a person who has experience and knowledge in that field. Industrial applicability means it can be produced, it can be have some application in a particular field, and it can be like scale up for industrial applicability. So these are the three criteria that you have to check before you are making an application for the patent. So this we have already seen, like here the important thing is that the maximum duration for which a patent can be covered, that is based on the renewal. And the authority in India is controller of patents. Head office is in Calcutta and the branches are in New Delhi, Madras and Mumbai. Now why to file patent? I will show you last, like we have also like lot of publication and etc. Like when I was doing PhD in like in 2010, 11, at that time, or 11, 12, at that time we used to majorly focus on the research publication. But now now the government is also promoting that we can file patent, we can register our innovation, because once you have published it, you lost all the like possibility of getting that exclusive right, because now the technology is in the already it is in the available for all others to make further advancement. But you can do one thing, you can patent it and then you can publish in a way that it can't be reproduced by the others before you can make like industrial application for the same. So to claim ownership, you need to patent it. Monopoly, to sell or if you want to license it, and this also help in making the invention public. Encourages further innovation, and enforcement means if someone infringe your rights, you can also have right to file a case or stop him from using your invention. Who can file the patent? So any person who is the inventor or any assignee of the inventor, or maybe the legal representative. All these can file the patent. Now we will see some practical aspects when we file patent, what we require. So in this, when you are filling a patent application with the Indian Patent Office, you will have to take care, means what are the requirements that are enlisted here, that you can see. There is a cover that will indicate the list of the documents. You will have to file the application for grant of patent in the form 1. You can see this form 1 in the screen. What are the different components, where you can see you will have to give the details regarding the applicant and inventor. These could be, you may be thinking how they are different. Means inventor will be the applicant. It is possible, and it is also possible that inventor will be different and applicant will be different. For example, like I am working as assistant professor in Naipar Raebareli. So when I invent something, because my employer is Naipar Raebareli, and whenever we file the patent, so here the applicant is Naipar Raebareli and inventor is me and my team. So research team, obviously I have to give credit them, because of them I could be able to make any invention, like my scholars, MS Form and PhD scholars who work on that invention. So all of us they are in like in the team of inventors. Then in the form 2, there will be complete specification. Here you can see there are only 4 components. In the next slides, you will see these components in detail as well. So in this, there will be description, there will be claims, drawings, abstract. These are the 4 major parts of the form 2, in which you will give all the specification of your patent. There are 2 types of specification that we can file. One is provisional specification, the other one is complete specification. Suppose you have an idea and you have supportive background information for that, and you need some time, like it will take some time to generate or prepare the prototype, but you want to get the advantage of prior date, because the date you will file na, that will consider as a date for the claim, because if someone else will file it before that, then you will lost your claim. So what we do, if we have an idea and we have sufficient scientific proof to give a proof of concept, then for that idea we can also file it as a provisional specification, and then we can get a duration of 1 year, that is 12 months, in which we can file the complete specification giving all the details regarding that invention. But it should be filed before expiry or before completion of those 12 months. Then there will be some other forms like statement and undertaking, form 3, power of attorney. We had previously filed it with like patent minder, and now we are also taking the services of like patent minder is also continuing working on the patent that we have already filed, and also with the NRDC. These are the patent facilitator center. Then is NRDC. Apart from that, there is also TIFAC is there, PIC is there, other centers are also there. Then we will also give the declaration of inventorship in form 5 and the certified true copy of the priority document and requisite statutory fee. So here you can see what are like form 2 is for the description of the patent, in which you will give all the person that will include the drawings as well, the claims you are making. Claims are very important part of any patent, where you will say what makes your patent inventive, novel and industrially feasible. This is for form 3, that is for invention disclosure, like you are the inventor of the any invention. This is form 5 and this is form 26. This is for like patent attorney. You are giving the authority for the patent agent to work on that patent on your behalf. But before starting this process of filling, you will have to make sure there is regarding the precaution that you have not to disclose the patent claiming. Means you need to not disclose it before filling for the patent, and you have to make sure before filing a patentability search to see whether it is patentable or not. Okay, so like discussing it with someone or some entity for any purpose, you have to make sure that you get a disclosure agreement signed, that they will not disclose it to anyone, and this is your property and they are working with you. So there is a confidentiality disclosure agreement, CDA, that is required to be signed. You should not publish before filling. After filling, you can publish, but then it will make it available for the public, and further innovation may be made by some other one. So filling for patent or not. तो सरकार मेरे पास आ गया है indication की we have like I have means I think 5 minutes, sir. So this information is little important, although, but I will cover the main points that will be important for you. So for prior art search, You can normally we go for only like literature, publication, etc. But you also need to search the patent that are already in pipeline or that has been filed by someone else, or that has been already published, or that has already been granted. So that you can do with the help of in-pass. Okay. So before this, this in-pass is there, that was introduced in 27 February 2015. Before in-pass, there was I-pairs, but this in-pass has more advanced feature where you can get information regarding all the Indian patents. You have to just file the, maybe you may file the area of invention, you may just write the number of application from which you can get information. And apart from Indian patent data is also available at So in drafting, I have already told you there are different parts. First one will be the basic, that will include all the specifications. Here the abstract is mandatory, that you have to include. You will have to give the field of invention, background of the invention, what is already the knowledge. On the basis of that you have invention has the inventive step, then the available knowledge. So these are the components in that I told you earlier na, that in that you have to give the patent descriptions. In this you will have title of invention, field of invention, background and prior art, what had been done before this. Summary means you will give all the overview. There will be some example drawings, and the one of the best method or working examples you can give here. So now 2-3 slides are there only that can give you the like regarding what are the fees. So if you are filling it as an individual, you have the fee of like 1600 at the time of filling of the application. And if it is for a small entity, then a small entity it is 8,000. So this one is revised one. Previously it was higher. Then it is generally when once you file the application, the patent will be published after 18 months. So for that you don't need to pay any fee. But if you want early publication, then you will need to pay a fee of like 2,500 for individual inventors. Here you can see that this is the receipt generally generated after you file any patent. Then after 18 months, you can do this for examination that should be filed within 48 months of the filing date or priority date. So the date is like you can file it after the publication, and this can be also expedited, and for request is 4,000 rupees. And for a small entity it is different, and if you want expedited it to be examined at the earliest possible, you can pay the extra fee, that is I think 8,000 rupees for the individual entity. So these are all others, like there are some other drafting and filling. These are the professional fees also given there apart from the government fee. The previously that I have told you, these are the government fee that is implied by the patent office when you are filling for a patent. There is also, if you are taking the help of the professional, it may vary. It is not like it will be only 15,000 only. It depends. The help of or the services of the patent agent or patent facilitating center you are taking, they may charge different depending on the service. So that's all. Here you can see these are our like patents that we have filed from our lab. These are few publications in 2024. So thank you to my organization, NIPER Raebareli, and the organizers, Dr. Jawahar and BBAU for giving me this opportunity. And this is my family of NIPER Raebareli. Thank you. Let me take one more.
We appreciate your presence, ma'am. Your explanation was really informative. I request Dr. Raj Shree Pandey to please honor our dignitary by offering a memento.
Thomas Edison said, innovation is 1% inspiration and 90% innovation. Today we celebrate both. Mr. Balram Singh is working as a patent attorney in the field of intellectual property and technology management, IP prosecution, IP search and analysis, transfer and commercialization of intellectual property and IPR awareness training. He is certified as a patent agent from Indian Patent Office and certified trademark agent from the Trademark Registry India. He has LLB in IPR specialization, master degree of engineering in instrumentation, bachelor degree of engineering and PG diploma in technology management and ARM Hyderabad. He is working as a patent facilitator for SIPP for Startup India, DIPP Government of India as a mentor of Atal Innovation Mission, Niti Ayog. Please join me in welcome to Patent Officer Mr. Balram Singh on the stage. They will share their insight on intellectual property rights, practical aspect of drafting and filing patent.
I think it will be good. Okay. Thank you everyone. पूरी खाई थी तो नींद तो नहीं आ रही. So first off, thank you BBU to interact you all, and thank you organizer and honorable VCs and everyone. So I would cover very fast because all the different matters is already covered in your previous speakers. Recently have covered already some part of patent. So I will avoid to repeat the basic theory part and those cover which is already covered. Because if we put the theory, it is very easy. We are living in a AI generation. We are AI. If I put the theory knowledge, then it will be easy for you to, you will get that knowledge through your chat GPT, that Google, everything is there. Deep Seeker is also available. And last night I uploaded my PPT on chat GPT, and just I told her, please present it. So she was very more efficient than compared to the me or any human beings. So knowledge is very easily available. Why we are organizing this seminar? Because the humanization is very necessary. Now I am going to share my experience. I am in IPR from 2016, and before it also is in research organization. So I will only share my experience and all these things. It is not moving. Okay. Anybody help me? It is not moving. Okay. me check. Yeah.
बैकग्राउंड में जो चल रहा होता है डेस्कटॉप पे सेव करके ये डेस्कटॉप पे सेव करके लैपटॉप चेंज कर लेंगे.
सर एक बार नहीं उसको कॉपी कर लें.
This one is
Yes, yes. निकाल दो.
ठीक है दूसरा लैपटॉप यूज कर
निकाल दो सर इसको.
बेटा आप लोगों के लिए एक शॉर्ट अनाउंसमेंट है. एक अटेंडेंस शीट चल रहा है जो आप लोगों ने किया ना, उस पे अपना नाम एक बार आप लोग चेक कर लीजिएगा. वही नाम आपका सर्टिफिकेट पे जाएगा. वी आर नॉट गोइंग टू चेंज आफ्टर दैट, यू नो, आफ्टर द सर्टिफिकेट. तो अटेंडेंस तो काट के करेक्ट नाम कर दीजिएगा.
सर सेव कर लिया.
लगा दूंगा.
डेस्कटॉप पे तो कॉपी कर दिया है.
हाँ
ये प्रेजेंटेशन मोड में है.
अच्छा एक मिनट हटो जरा. क्यों बार बार आ रहा है? ये है
ये वाला. Yes, now it will work. Sorry for this technical glitch. So you know what is IPR? First, I put it is a legal thing. It is not my professional advice. It is just for the teaching purpose, and it is not taken as a professional advice. You know what is the IPR? You already know. Anything which is created by mind. Now we are making notes. It is also your intellectual property. Nobody can use it without your permission. It is somehow similar to your physical property, like your laptop, phone, property, your bike. These are your property in which you have ownership. But in intangible, intellectual property, your mind, what your idea, your creativity, also one type of your property, and these property are protected under intellectual property. सेकंड थिंग, इट इज फॉर लिमिटेड ड्यूरेशन. आपका लैपटॉप आपका ही रहेगा, बट पेटेंट में ऐसा नहीं है. 20 years के बाद इट विल बी एग्जॉस्ट. एंड फॉर कॉपीराइट यू ऑलरेडी नो द टाइम ड्यूरेशन. You can sell, rent, assign, license, everything. What your idea, what a patent you have. जैसे हम फिजिकल प्रॉपर्टी करते हैं, आपके चले जाने के बाद आपके बच्चों को जैसे प्रॉपर्टी ट्रांसफर हो जाती है, सेम मैनर योर इंटेलेक्चुअल प्रॉपर्टी विल ट्रांसफर टू योर लीगल हेरिटेज. And different property, different registration. आपकी बाइक है तो you will get the RC. RC is the proof that this bike belongs to me. आपका घर है तो आपका रजिस्ट्री होगी. So in the same way, there are different type of intellectual property. You already know patent. It cover invention, right? It cover literal, musical. So this different type of intellectual property registered under different type of office and different type of tool. We call it as a patent, copyright, trademark, design, everything. You know already it is covered. Why we provide, why IP is important? Because we want to reward the innovators and we encourage innovator to disseminate their knowledge to the public. अगर हम उनको encourage नहीं करेंगे तो they will not disclose their information for the society. For example, I have invented some very important drug, and if I want to keep it state secret, then it will be not beneficial for the society. So government assured that okay, you disclose your information full to the public. We will provide you protection in form of patent, at least for the 20 years. That nobody can use, nobody can commercially use your invention without your permission. And encourage the creativity or innovation. So people come with the different solution of problems we are already existing in the society. This is the whole circuit, we have to create first, then identify the ownership of who is the owner of that particular creativity. Then we protect it through different IPR tool. Already known from the morning you are listening IPR, all the thing. We protect through that particular tools. Then after the protection, we commercialize it and we put it into the market. So if any idea coming into the market, then you have to think that what tool I need to, what is the patent, what is the copyright, what is the trademark, what is industrial design, you know it very well. Any idea you are coming, first you have to identify which tool is necessary to protect that particular idea, creativity or innovation. You have to identify, is it invention? Then I will file patent. Creative work, literary work, musical work, dramatical work, presentation. For example, I am presenting here. It is also my copyright. If someone making a video for me, if I providing consent, then only he has the rights. And design station, geographical indications. These are different type of intellectual property rights. It is summary of intellectual property right. Type of different, you already know all this type of different IP have the different time durations and different act and rules are applicable for different type of intellectual property. You already known from the morning you are listening this word patent, design, trademark, plant variety protections, trade secrets, and all this copyright and everything. In patent is already covered by ma'am very well. I want to add something that it is negative rights. It rights to exclude others. Patent doesn't provide to use your invention as a commercialization. आपने पेटेंट फाइल कर दिया इसका मतलब ये नहीं कि आप उसका प्रोडक्ट बना सकते. मे बी योर इन्वेंशन इट डिपेंड ऑन अदर इन्वेंशन आल्सो, बट व्हाट इज nobody that particular improvement or that particular change can't be used by others. But if your invention depend on other patent, then you have to take permission for the patent. Second thing, it is based on your public to disclose each and everything about your patent to public. अगर आप पेटेंट में कुछ छुपा लेंगे तो it will be objection for the patent office. They will raise the objection that you are not disclosing, because you are disclosing everything to the general public. In behalf of that, patent office is providing a monopoly. As morning sir were telling, Thomson Edison ने बल्ब का आविष्कार नहीं किया था, उन्होंने बल्ब का आविष्कार नहीं किया था, उन्होंने उसका पेटेंट उनको सबसे पहले मिला था. जो डिफरेंट पेटेंट्स अलग अलग बल्ब के मिल रहे थे उस टाइम से. एंड व्हाट इन अनदर टाइप ऑफ इंटेलेक्चुअल प्रॉपर्टी इज इंडस्ट्रियल डिजाइन. In industrial design, we protect the external shape and size of any device or machine, not the technical concept. Any shape, configuration, composition of patent, it is protected under the industrial design. For example, यहाँ bottles आपको दिख रही है. The technical concept of all the bottles are same. They are container of water. They have some, but their design is different, and each have their design patent. General language we call it a design patent, but it's not design. We call it as a design. That each their concept, technical concept is the same, but representation, the 3D, 2D appearance is different. And in design cases also should be new in appearance. जैसे कोई कुर्सी है, कुर्सी का बेसिक कॉन्सेप्ट तो ये सेम है कि एक बेस होगा, उसके सीटिंग होगा, उसकी पर इनकी डिफरेंट डिजाइन होती है, तो हर डिजाइन का पेटेंट फाइल कर सकते हैं। एक पेन, बेसिक कॉन्सेप्ट आपका सेम, बॉल पॉइंट, एक सिलेंडर होगा, सम ink is there, some ball point is there, basic tech. First patent was filed for the patent, then you can file a number of design for it. And non-disclose in public, it is also requirement to get a design applications registration. And some of the design is not, because it's already available in public. If you simple ask to any AI chatbot, will put you. So if you want to launch any product, you have to protect it through different intellectual property. Like for your smartphone is protected by the different intellectual property, like patent. There are a lot of technologies there, so it is protected under patent. Some copyrights, some software they protected under that copyright things. And if so, it is protected. I'm putting this example of pressure cooker. These three pressure cooker are different. Their appearance is different, so their design patent is different. Their technical concept is different, so we have to file a patent application for it. And their different logo is placed on it. Then we have to file different trademark also for it. So what is the patent? You know, if your invention means any products or process or composition and system which is novel, non-obvious and useful, then you can file a patent application for it. It is for 20 years. And first to file system is there. But just I want to correct here. Recently government had provided a 12-month grace period. It is already there in Patent Act, but they have used, if you have published your patent application within 31 months and you have disclosed any publicly, for the example, for the purpose, or you communicate to the government for any project purpose, then it can be protected. But it is always advisable that you should file first patent application, then publish. But grace period is already there. Within 12 months, you can file your patent application. Patent Act, 97. What is patentable? Everything is patentable, but it should be novel, non-obvious, all of industrial application. Novelty, industrial application is also, in non-obvious is very broad term. And दे देंगे किसी डॉक्टर, then it's not good for the humanity. अगर कोई ट्रीटमेंट या डायग्नोस की मैं डेवलप करें तो okay, it is important. Don't publish before file patent filing. You should remember one thing. You are. I think you have already known this thing. Simple invention are also patentable. हम वेट करते कि नहीं नया तो है नहीं मैंने. It's not very simple to simple invention is patentable if you have something. If you change, you have performed very small changes. If it is adding a technical effect, then you can file a patent application for that particular small change, not a whole product or process or composition, but it should add some technical effect. No as such worldwide patent. You have to file a different patent application in different country if you want to protect your invention in different jurisdiction. Software is patentable. There is some doubt in most of cases. I am making a computer application is not patentable. It is patentable because recently the High Court has issued such guidelines. If your software is adding a technical effect in any hardware, then you can file a patent application for it. So it is a line of US Supreme Court. Everything under the sun is patentable. You can say it. There are 4 patent office, and if you are filing patent application from the Uttar Pradesh, then our patent application will move to New Delhi Patent Office. Who can apply? You can apply. Your assignee can apply. Your organization can apply for patent application. And your legal representative, आपने invention की आप दुनिया को छोड़ के चले गए तो आपके बच्चे भी आपके बिहाफ पे patent application apply कर सकते हैं. These are the form. These are already covered by previous speakers. Power of attorney, Form 1, Form 2, Form 3, Form 5, Form 9. 2 type examination. In Form 1, we file your general information, name of inventor, name of applicants and everything. Form 2, we file a detailed description of, because we are disclosing our invention to the general public. So in Form 2, we will put all that thing, title, background, complete specification, drawings, everything in Form 2. Form 3, if we are filing outside India, if we are filing patent application, then we have to put Form 3. And in Form 5, declaration of inventorship is there. These are the inventor. If applicant and inventor are different, then we have to file a Form 5. Patent office will publish patent application within after 15 months. But if you want to publish it within 1 month, then you have to file Form 9. And in examination, if you want normal examination, then you have to file Form 18. And if you are woman, or a startup, or MSME, or government organization, or your education institute, in this case, you can, if you want to expedite your examination, then you can file an expedite examination. No, सब कोई फाइल नहीं कर सकते. अगर एटलीस्ट वन वुमेन एप्लीकेंट होनी चाहिए, या कोई स्टार्टअप हो, या MSME हो, या कोई गवर्नमेंट ऑर्गेनाइजेशन हो, any institute established by the center or state government. Then you can file expedite examination. So if expedite examination में patent office is providing grant within 5 to 6 months, it is very good for, and then Form 28 to as approved. So only there two fee schedule is there. If you are a individual person or MSME or startup or education is, for example BBAU, recently कुछ year पहले 8,000 वाले clauses आता था, but इसके बाद पेटेंट ऑफिस ने कहा है कि जो एजुकेशन इंस्टीट्यूट है, देयर इज वन डेफिनेशन ऑफ एजुकेशन इंस्टीट्यूट, इफ यू आर established by any act or rule of government, then you can, your fees is reduced from 8,000 to 1,600. और काउंसिल ऑफ साइंस एंड टेक्नोलॉजी अगर फीस फाइल करेगी तो उनकी फीस 8,000 आएगी, बिकॉज काउंसिल ऑफ साइंस टेक्नोलॉजी इज नॉट ए एजुकेशन इंस्टीट्यूट. दिस इज द प्रोसीजर. इफ योर इन्वेंशन इज फुल्ली रेडी, then file a complete specification, and you can file a application also. So it will be published in 1 month. If you are woman, at least one woman, then you can file a request of examination at time of filing, and within 6 or 8 months it will be granted. If you file expedite examination and in current scenario, if your invention is not ready, for example अभी आपको एक आइडिया है बट आप उसके लिए रेडी नहीं है, सिर्फ कॉन्सेप्ट है आपके पास, then you can file a provisional patent application. और in provisional patent application you have a time of 12 months to file a complete specification. Then issue of examination report, then hearing also. Anybody who want to oppose the patent application, he has your patent application after publication of patent application. Within 1 year, any interested person can file a proposition also. ग्रांट मिलने के बाद भी हम नहीं बैठते. हो सकता है कोई इंटरेस्टेड पर्सन का मतलब है one person who are conducting research in it, who is step commercially use that particular invention, can file a post-grant application within 1 year from grant of your patent application. So this is full procedure. Now patent office is total only need physical document, demand drop also. If you file online, I was mentioning fees was online. If you file offline form, then fees 10% will be enhanced. So it is always advisable you should online forms. You can make profile on this by yourself, but वैसा ही है, if you can treat your, if you are suffering from a disease, you can conduct a search Google and you can treat yourself. But it is always advisable कि आप किसी डॉक्टर के पास जाएं, उससे ही और फाइनेंशियल लिटरेसी बाय योरसेल्फ. बट इफ विजिट टू अ CA to take a profession, because patent is not such a research paper, and it will be read by quote your competitor who want to copy your invention. वो आपकी गलतियां ढूंढेंगे कहाँ आपने कुछ गलत किया है, and your scope for your protection. If I am using sensor and I am using XYZ sensor, then meaning is different, because I am claiming only that particular XYZ on or at, totally differently. So drafting patent application, I am going to discuss about it. After you will get such a certificate from the patent office. Unnat Pandey is currently Controller General. These are the session already. If you are taking patent attorney, then you have to free and fairly discuss with the patent attorney as you discuss with your doctor, because if you disclose everything, then only can treat you. All the information you have to disclose. हमें लगता है कि हमने तो हाँ उस पेपर से हम ये नहीं बताते, but it is wrong practice. You have to disclose everything, क्योंकि उस हिसाब से हम फिर क्लेम को मॉडिफाई कर सकते हैं. and we have to incorporate all the possibility in it, because patent is document of future. In future, competitor will try to modify something and make product, then it is advisable that we can disclose all the information in it. It is now I am coming to the international system of patent application. If you have filed an Indian patent application also, you have 12 months time in both. There are two channels by which you can file international patent application. In general language, I am saying international patent application, but it is not such an international patent application. Means you can file different patent application in different country. First is the Paris Convention route. After filing Indian patent application, you have 12 month time. आपके पास 12 महीने का समय है कि then you can file any. आपको लगता है कि आप जापान में अपना प्रोडक्ट लॉन्च करने वाले हैं, तो within 12 months you have to file patent application on that particular country. Your protection will be filed in India. आपको प्रोटेक्शन उसी डेट से मिलेगा जिस डेट से यहाँ इंडिया में फाइल हुआ है, पर आप जापान में 12 मंथ के अंदर ही फाइल कर सकते हैं. बट इसमें क्या दिक्कत था कि यू हैव टू फाइल अ पेटेंट एप्लीकेशन इन डिफरेंट लैंग्वेज. वहां के the procedure was very hectic. So Paris Patent Cooperation Treaty is there. You can file a patent application in India. Then 12 months you can adopt this PCT route. Then within 31 months you can enter in any national phase. So industrial design, any safe configuration or any external appearance is protected under the industrial design. And because कई बार होता है कि जो दिखता है वही बिकता है. Sometimes our product, their appearance is very important. So sometimes commercial value lie in your appearance of their product. Then you can easily file a design, industrial design. It is provided for 10 years, which can be enhanced for 5 years. तो total life cycle इसका 15 साल होता है. Initially it will be registered for the 10 year, which can be enhanced for the 5 year also. And it should be new in sense of appearance, and it should not be available in the public domain. It will be available, then it will be not registered. And in design application also, first to file system, if you file first, then you will get registration. Some of the thing is not registrable under Design Act, so I'm skipping it. You can search it. So what is the fees of design application? Only 1,000 rupees. If you want to file a design application as an individual person, in 1,000 you can apply for the design application. And if you are MSME, then the fees is 2,000. And if you are large entry like BBAU, his fees is 4,000. But you have to identify the class of your design. For example, for the laptop, there is a different class. For the pen, it is a different class. For any device, it will be different. There are 32 classes in there. You can search out and identify which class is suitable for your particular design. Because in your application form, we have to mention the class, name, address. This is the application form for design. Very simple 1-page or 2-page form, in which name, address, nationality, class, and there are 4 sets of representation. Now it's not necessary because the whole process is online. So only one copy of a representation sheet. You have to. What is the representation sheet? I am going to tell you. In which you submit the photograph of your design application, not any step, not description, not everything. You just need to all the view of your device. There are 6 or 7 views: front, top, bottom, perspective. These are the view you have to submit in representation sheet. Power of attorney, if you are submitting it through any patent attorney. And priority document, if you have an application in outside of India and you are taking priority of that document, then you can submit this document. And is the main office for design application. All the design application move toward the Kolkata. In any jurisdiction, if you are living in Uttar Pradesh, then you have to file a design application in Kolkata. Automatically, online system, it is automatically submitted to the Kolkata office. If we file design application, then it will be examined, then it will be published. Patent में क्या होता था? पहले publish होता है, उसके बाद उसका examination होता है. In design application, first we file, then it will be examined, then it will be published if it is accepted. And if any objection, then they will raise the objection. We have some time, around 6 months from the issue of file of design. We have 6 months time to any objection comes. this is the whole procedure. It is this is the one sample of the representation sheet in which you have to put all the photograph of your design in all view. Below it, you have your representation sheet, name of the applicant, and then sheets should be mentioned. I have already discussed about it. And also in design, industrial design, you can also file through totally online, not need to visit or submit that forms physically through post office. It is not necessary. Okay. Now, and this is the certificate of design patent. It is somehow similar to the patent, but if you see, it is design registration. This is the certificate, and you will get this certificate within 3 to 4 months if you file a design application. Now design fast, and even patent office is very fast. They are providing grant within 6 months if you file expired examination. You know what the difference between design and patent. In patent, we claim the technical concept, any product process system. In the design, we protect the external appearance. And Design Act 2000 gone by design gone by 2000 में ही मुझे पेटेंट देना है. अगर मैं उसको पेटेंट में डाल दूंगी टू किल अ ह्यूमन बीइंग टू पेटेंट provide but use vegetable, then okay. So you have to find out it or not. These are the things. Type of the invention within words you have to pick. Field of the invention means electronic, pharmaceutical, electric, chemistry. Kiss field के not 2 lines. Breakdown. In background section we put what are the problem we are solving. Not necessary to put all the things जैसे हम research paper में put करते हैं. But only the breakdown. What problem is already there. यहाँ पे हमें solution नहीं बताना background section में. Only the problems. These are the problems. Summary of the invention, you know, and drawing of in flow chart. Brief description of the drawing. Simple, and the detailed description of the method, the detailed description or base method. We have to provide at least one example in our detailed description. हमारा concept level पे हम patent file नहीं कर सकते. At least we should have one example of our invention. At least one experiment data we should have. And claim. The claim is the most important part. जब पहले पेटेंट फाइल होते थे उनमें क्लेम नहीं होते थे, बट जब लीगल केस लड़ा जाता है तो आपने क्या क्लेम किया था, क्या डिस्क्लेम किया था, इट वाज वेरी difficult to judge for a claim. Means we are not claiming it. And we always use the broad term, so cover all the possibility. For example, brush, I will not use a brush in our patent claim. I will use as a clinical article. Pen, I will write as a writing instrument like that. Mobile phone is not mobile. I will use as a wireless communication device. And there are two important parts in claim: independent claim and dependent claim. Independent claim is independently is sufficient to disclose your invention, and dependent claims are depend on and they cover all the possibility of your invention. If you are going to draft your claim, then there are 3 parts in any claim: preamble, place, and the body. If you want to draft your claim for a particular patent application, there are 3 things. In preamble, we disclose our objective of our invention. In upcoming slide, I will show some example. In transition part, we use comprising, including, consisting, are the open or closed phrases, and the body. The body contains all the component and feature of your invention. So this is the structure of your claim. And whole word anywhere आप कहीं भी जाएंगे यही structure follow होता है patent draft में claim का. We start the claim with a system, method, apparatus, composition, everything. जो भी आपका claim है, for objective, आपका objective क्या है वो आपको mention करना है. Then wherein that particular system method comprises, what are the essential component to perform your invention. We should put it in your claim part, because if you put a non-essential component, that it will be beneficial for our competitor, because now our scope is narrowed down. Then second and third, all this component you put it, and last component you put end, and then wherein you put all the future their interconnection. For example, मुझे चाय बनाने का पेटेंट फाइल करना हो, तो my preamble will be a method for making tea. But if I action, then I can claim it a method for making a warm beverages. This is the preamble part. Transition first, there are two types of transition: open-ended transition, comprising, including, containing is open. Means I am claiming A, B, C, D, but it may contain C, D, E, F also. At least I am claiming A, B, C, D. It is open-ended. I am not invention to particular A, B, C. I am saying there come B, C means it may be contain C, D. Closed, we use closed particular. If I am claiming consisting means I am only claiming A, B, C. So it will be easy for patent office to provide grant me, because now I am claiming only the A, B, C. It is not open-ended. So you have to put all this in mind while drafting your. For example, an apparatus. For example, one claim I am reading. Apparatus for holding item comprising at least one leg and a top configured to support at least one leg. अब किसका पेटेंट है ये पेटेंट है आपका टेबल का. An apparatus for holding items comprising at least one leg होना चाहिए, क्योंकि टेबल में एक लेग भी हो सकता है, दो भी हो सकते हैं, चार हो सकते हैं, 10 हो सकते हैं. एटलीस्ट आई एम क्लेमिंग एटलीस्ट वन लेग. अगर कोई भी एक लेग भी बनाएगा, देन आई विल सेंड हिम अ लीगल नोटिस एंड अ टॉप कॉन्फ़िगर टू सपोर्ट दैट एटलीस्ट वन लेग. अब कोई भी कॉम्पिटेंस में से इतनी सारी टेबल है, कोई भी नहीं बना लगे, पर द बेसिक पेटेंट इज ऑलरेडी under my that particular claim. The apparatus for holding items comprising at least one. If I use for holding items consisting at least one leg, इसका मतलब है कि सिर्फ एक ही लेग रहेगा ओनली. तो इसमें से जो वन लेग वाला है वो कोई कॉम्पिटिटर नहीं बना पाएगा, उसके लिए उससे मुझे परमिशन लेनी पड़ेगी. तो नाउ यू अंडरस्टैंड मीनिंग ऑफ कंप्राइजिंग कंसिस्टिंग, एंड वी पुट लाइक दैट एट लीस्ट वन लेग आर प्लुरलिटी ऑफ द सेंसर्स, लाइक दिस टाइप ऑफ टर्मिनोलॉजी. अगर दो सेंसर तो चार सेंसर भी हो सकते हैं, लाइक दैट. इफ यू नैरो डाउन, इफ यू यूज कंसिस्टिंग वर्ड, देन इट विल बी इजी फॉर पेटेंट ऑफ एग्जामिनर टू प्रोवाइड ग्रांट इन इट, क्योंकि सिर्फ वन लेग को ही क्लेम करें. नाउ आवर स्कोप इज नैरो डाउन, ओनली वन लेग वी आर क्लेमिंग, सो इट विल बी इजी फॉर, बट आवर स्कोप इज नैरो डाउन. दूसरे कॉम्पिटिटर अलग तरीके से दूसरी तरह की टेबल बना देंगे, दो लेग के साथ, तीन लेग के साथ. दिस इज द लैंग्वेज ऑफ पेटेंट. Method boiling water, this is the method claim. It is preamble. A method is a preamble. For preparing tea is a purpose, objective. Comprising is not only this method, इसमें और भी, इसमें मैंने शुगर डालने की मेथड या उसको अदरक डालने का, चाय की आपकी तुलसी डालने की मेथड, पर इतनी दिस आर द इसेंशियल स्टेप्स इन अवर इन्वेंशन. तो उसको मैंने होल्डिंग, boiling first stage, second stage, third stage. In second case, it is also a method for making tea, but in this we are narrow downing our scope. So these are to the money. We have to follow different protection, commercialization, and the licensing. These are some interesting patents. Michael Jackson have filed their patent application for the anti illusions. आप होगा जो उनकी शूज है 45 डिग्री तक, तो उनकी स्किल की साथ में ये उनका पेटेंट भी था उसमें. Body bomb, if you are in corona, you can dance with your partner through simulation. This type of patent is there. This is also patent to care about your pet and the child fear from the. This is also patent. If you want to lose your weight and want to how you are taking in eating, then you can find. It is simple thing. So is my presentation. Thank you very much. If you have any question, then you can ask me. Yes.
How much fee is required to, like after 3 years of the patent, to provide to keep for retaining the patent?
Renewal of the patent. Yeah. If you
Renewal or just retaining the patent?
Retaining, use the terminology also.
That,
For initial 5 years is 800 per year. Part of After the grant, we have to put renewal fees. Patent office, because you have monopolized technology. So it is type of tax they are taking. If you have some fees to the patent office. So it's 5 years, 800 for the initial 5 years. For the second year, you have to pay for third year, you have to pay the fees. For a 5 year, you have to pay 800. Then you have to pay 1,400 for the upcoming 5 years. Then it's 4,000. I think this. But you can pay advance or you can pay yearly basis. Any other question if you have later? Yes. First challenge to identify the novelty of invention means now technology is complex and interrelated. We have to identify which part of invention is novel. Second, drafting is one more important part. वही patent if you know 6 degree पर मुझे पानी को गर्म करूंगी patent office usually हमें I am claiming only 5 to 6 degree only. Then patent office will easy for them to provide grant. So what scope we will, how much initial component we have. These are the second thing. Really fast, so delay is not here. पहले delay भी एक problem थी patent office की, but अब काफी fast हो गया patent office. So it will be easy. These are the some major problems you can face. But like you don't need to worry about it. जैसे you have to disclose simple information to your eye. Then the drafting, preparing the form, their duty. Not expected from the inventor of the form and draft the patent. उनकी लैंग्वेज में हम रिस्पॉन्सिबिलिटी रहेगी कि उसकी ड्राफ्टिंग वो करें एंड फाइल और जो भी लीगल प्रोसीजिंग है वो लिखे जी
very sincere, but I want to know that whether the artistic, whatever you have said, the representation document, the artistic diagram, up and down, does it affect the artistic because all picture and those drawings for a person, according to his devices. And can be filed for the patent. Okay.
For patent or design, you are asking for patent or design?
Design patent.
For design patent?
Design, yeah.
The online tools are there for designing any tools you can use. But it should be sufficient in design application. In patent, you can file a sketch drawing also. In patent form, not in design. In patent, you can submit block diagram. You can submit the sketch also. So design, you have to make the proper sketch design. Online tools are number of tools are there. You search out a number of things that there are some Adobe tools are also there. Microsoft is also working on it. The free tools are also there. Canva is also there. The number of tools. No, handwritten drawing is not accepted in design. Because in design application, we are only can cut your name and put his or her name. You lose the commercial quality. जैसे कोई अभी पेटेंट किसी ड्रग्स का पेटेंट एक्सपायर हुआ था तो उस ड्रग्स के पूरे कॉस्ट ही कम हो गई कैंसर ड्रग्स की. तो उसके बाद जिन्होंने इन्वेंट किया था उनका नाम हम हटा नहीं सकते. क्योंकि इस तरह से अगर 20 ईयर से भी ज्यादा हम मोनोपोली देंगे तो किसी एक बड़ी कंपनी के पास ही सब कुछ मोनोपोली हो जाएगी इन फार्मास्यूटिकल टेक्नोलॉजी एंड एवरीथिंग. पेटेंट का ऑब्जेक्टिव ये है कि हम लिमिटेड टाइम के लिए मोनोपोली दें 20 ईयर्स के लिए, तब तक वो कमर्शियली उसका यूज कर सकता है. 20 ईयर्स टेक्नोलॉजी टोटली चेंज, जो आपका इन्वेंशन वो इतना वैल्यूएबल भी नहीं रहेगा. तो ना इट विल ऑटोमेटिकली ट्रांसफर within 20 years it can be transferred. After 20 years, your name will be there, but your commercially you can't use it. No, but you can't transfer it because it is already withdrawal. It is finished now. Life of patent is already finished. You can't transfer it. Even you transfer to agreement, then it will be not useful for him because they can't enforce their rights. हम किसी को लीगल नोटिस नहीं भेज सकते कि ये अब ओनर पेटेंट का ओनर ये है, बट आप किसी को लीगल नोटिस नहीं भेज पाएंगे. दिस इज द इश्यू.
Can we take patent life-saving drugs?
Yes, we can take photograph. No. No, don't need to take permission. Means patent is just a registry. आपने जमीन की रजिस्ट्री कर दी तो रजिस्ट्री डॉक्यूमेंट दिस इज प्रूफ दिस प्रॉपर्टी बिलोंग्स टू मी. आप उसको आप खेती करेंगे, उस पर दुकान खोलेंगे, ये इट्स योर चॉइस. बट इफ इट इज लाइक अ ड्रग, देन यू हैव टू टेक द परमिशन ऑफ पर्टिकुलर ड्रग अथॉरिटी. दैट्स डिफरेंट थिंग. अगर आप कोई प्रोडक्ट लॉन्च करें तो फूड डिपार्टमेंट से आपको परमिशन लेनी है. दैट्स डिफरेंट थिंग. पेटेंट मींस जस्ट द रजिस्ट्री ऑफ पर्टिकुलर प्रॉपर्टी. दिस इज आई एम द ओनर.
I have an idea and I want to patent that by using a third party because I'm not good in drafting and so on. But that party, without my permission, patent that file because as you said, जैसे डॉक्टर को सब कुछ बताना होता है, वैसे ही सब कुछ हमें उनको हमने बताया, लेकिन without informing me, they file the patent. मतलब कैसे protect करें this type of scenario?
In our practice, we first sign a non-disclosure agreement. आप जिसको भी डिस्क्लोज करें से नॉन डिस्क्लोजर एग्रीमेंट पहले साइन करवा ले. दिस इज फर्स्ट स्टेज. टेक ऑलवेज द प्रूफ दैट यू हैव सबमिटेड दैट इंफॉर्मेशन टू हिम. देन यू कैन टेक लीगल एक्शन अगर कोई कॉपी करता है, बिकॉज आपकी जमीन पे भी कोई आके कब्जा कर सकता है लाइक दैट. So we have to take this measure. At least non-disclosure agreement is the first stage between attorney and inventor. Attorney sign in any form of submission, like you will submit only by through email or anyway you will submit information, you disclose your invention to that particular attorney. So all these things cover under the non-disclosure agreement. And also patent attorney or agent or third party is like responsible for the patent office also. They are professionals. Like we put our whole body to the doctor कि हाँ वो जैसा देखें, अब हम ऑपरेशन थिएटर में उनके भरोसे चले जाते हैं. In the same manner we have to use the service of a patent attorney.
जैसे हमारा मोस्टली हमारे रिसर्च पेपर पब्लिश होते हैं, बट डाटा मतलब होता है तो उसको रिट्रैक्ट कर देते हैं. वैसे पेटेंट भी हो सकता है. मींस अगर कोई क्लेम करता है दिस इज माय आइडिया और वो बाद में प्रूफ हो जाता है, तो क्या पेटेंट भी ऐसे कैंसिल हो सकता है?
They have the provision of patent office itself conduct a search. वो सर्च करते हैं, वो रिपोर्ट. एंड प्री ग्रांट अपोजिशन इज आल्सो देयर. एनी आफ्टर योर पब्लिकेशन और पेटेंट एप्लीकेशन, एनीबडी, पहले तो उसकी फीस भी नहीं थी, तो एनीबडी उस टाइम अभी रिसेंटली पिछले साल तो उन्होंने फीस भी लिया है, फीस भी लेते हैं अगर कोई प्री ग्रांट अपोजिशन करता है तो. सो एनी पर्सन कैन ऑब्जेक्ट योर दिस, प्लीज डोंट प्रोवाइड पेटेंट फॉर दिस पर्सन, दिस इज ऑलरेडी अवेलेबल. और पेटेंट ऑफिस देमसेल्फ आल्सो कंडक्ट अ पेटेंटबिलिटी सर्च. वो खुद कर सर्च करते हैं. दे विल साइट द रिसर्च पेपर. These are the related. Then we have to submit a defense कि how it is different from our invention. हमारे पास 6 month का टाइम होता है. और कोई अपोज भी करता है तो भी हमारे पास 6 month का टाइम होता है कि how our invention is. बाद भी anybody can oppose. For the one, not anybody, interested party can file a pro-grant opposition also. हाँ, ग्रांट कैंसिल हो सकता है अगर, क्योंकि पेटेंट ऑफिस देयर एग्जामिनर, उनसे भी गलती होती है. तो लॉ में हमेशा दूसरी पार्टीज के लिए भी नियम बनाए जाते हैं कि अगर दोनों पार्टीज के लिए हमेशा नियम होते हैं. ओके, थैंक यू वेरी मच.
Thank you, sir, for sharing your knowledge and valuable time with us. I heartily requested Honorable Dr. Jyoti Pandey ma'am to kindly facilitate to our speaker. Dr. Sailesh sir also.
heading towards the end of our expert sessions, we have Dr. Kailash Chandra Kulbe as our next honorable speaker. Dr. Kulbe is currently working as Principal Scientist, CSIR, Indian Institute of Toxicology Research, a CSIR laboratory under DSIR, Government of India. His expertise lies in IPR, technopreneurship, technology development, and its transfer, as well as in marketing of scientific services. Dr. Kulbe was awarded his PhD in synthetic organic chemistry from University of Lucknow. He earned his LLM degree in intellectual property jointly offered by WIPO, Switzerland, and the University of Turin, Italy. Sir also holds an MBA degree from Indira Gandhi National Open University, New Delhi. Sir was awarded a fellowship from World Intellectual Property Organization, a subsidiary to United Nations. Dr. Kulbe has addressed eminent academic gatherings globally. Let's welcome this acclaimed personality to share some interesting facts on IPR.
One little correction. Dr. Kulbe is Chief Scientist in CSIR.
No issue, sir. No issue. So, good evening. I need energy in my class. Good evening. How are you? Just fine. I'm not here to working since morning so hard, doing this, doing that, just to be fine.
Very excited to listen you, sir.
I want to, everyone should be happy. Acha, just laugh for 30 seconds. Laugh. Happy? Are you happy? Yes or no? Yes, sir. Yes, good. I want energy in my class. So now in IPR, you all have become expert. Since morning, you are listening one thing or other. I am not going to teach anything new. क्या उसी बातों को repeat करूं? Oh God, तो क्या बताऊं? बहुत मुश्किल है. Now you know about what is IP and what is IPR. Do you know the difference? The intellectual property, that what is inside your mind, the input whatsoever you have given is the IP, and the rights you are getting over it is IPR. Who is giving it? Government, individual government, Indian government. If you are submitting to India, you are getting the rights from Indian government. If you are submitting to India, Japan, Pakistan, Bangladesh, then all these countries, individually you have to file your application. ठीक है, ये था पहली स्लाइड. कितनी स्लाइड बोलूंगा? 3. लास्ट, ये दिस इज इंपॉर्टेंट. Just to rewind, IP is like any other property which may be bought, sold, assigned or licensed. जैसे अभी किसी ने सवाल पूछा था कि क्या मैं अपने बच्चों को, भाई को दे सकता हूं? जैसे आप अपनी कार दे सकते हैं वैसे दे सकते हैं, जैसे मकान दे सकते हैं, दे सकते हैं. यू कैन बाय, आप किसी पड़ोसी से खरीद सकते हैं, कंपटीटर से खरीद सकते हैं. यू कैन सेल, आपके पास है तो बेच सकते हैं. असाइन, मेरे पास हाउस है, मैंने किसी को असाइन कर दिया, आप किराए पे ले लो. एक असाइन किया कि अपना रहने के लिए ले लो, एक असाइन किया कि बिजनेस करने के लिए लो, एक किया जो करना हो वो करने के लिए ले लो, मुझे इतने पैसे दे दो. लाइसेंस, असाइनमेंट, पावर ऑफ अटॉर्नी देना. अभी जो सवाल थे किसी को दे सकते नहीं दे सकते, उसका ये जवाब था. और ये मेरी लास्ट स्लाइड है, मैं इसके बाद दिखा दूं आपको, इसके बाद ये वाली लास्ट है, इसके बाद खत्म हो जाएगा. तो आप लोग जितना भी बोर हो इसी स्लाइड पे हम लोग बात करेंगे. ठीक है, ये सुबह से आप लोग ये सब पढ़ चुके हैं, जितनी मैंने टाइप ऑफ इंटेलेक्चुअल प्रॉपर्टी पढ़ चुके हैं. which is the costliest, most valuable intellectual property? कोई आइडिया? हर एक के पास मोबाइल है। गूगल में सर्च कीजिए ट्रेडमार्क वैल्यू ऑफ एप्पल, कोई दूसरा सर्च करे ट्रेडमार्क वैल्यू ऑफ आईफोन, तीसरा करे ट्रेडमार्क वैल्यू ऑफ माइक्रोसॉफ्ट, कोई करे ट्रेडमार्क वैल्यू ऑफ सोनी, कोई करे IBM, कोई करे माइक्रोसॉफ्ट, कोई करे जो भी फाइजर, जो भी नाम आप मार्क वैल्यू ऑफ दिस पर्टिकुलर थिंग एंड टेल मी द फिगर्स इफ यू आर गेटिंग एनीथिंग। के पास कोई $574 बिलियन। कितने पैसे हुए पता है? क्यों आपको समझाने की कोशिश कर रहे हैं इंटेलेक्चुअल प्रॉपर्टी राइट्स, व्हाई आर दे सो इंपॉर्टेंट, दैट्स व्हाई आई एम ट्राइंग टू द इंपॉर्टेंस। 550 किसका था? एप्पल। व्हाट एल्स? एनीवन एल्स? किसी और को कुछ मिला? सोनी। 78 बिलियन डॉलर। ओके, व्हाट्स 70 हो, 80 हो, 90 हो, 100 हो, बिलियन डॉलर की बात कर रहे हैं, हमको क्या फर्क पड़ता है? बिलियन डॉलर पता है कितना होता है? पता है किसी को? कोई हाथ उठा के बता दे। 1 बिलियन डॉलर इज इक्वल टू हाउ मच रुपीज? में दिमाग लगाना पड़ेगा तो खुजली हो जाएगी। 100 करोड़। एग्रीड। अभी इन्होंने बताया था एप्पल का 550 समथिंग, तो 500 बिलियन इज हाउ मच करोड़ है? अरे 100 करोड़ तो 550 100 करोड़, 550 100 करोड़ ना। अब नाउ दिस इज डॉलर, नाउ कन्वर्टेड टू रुपीस, हाउ मच इट इज? Just, I am not telling you the mathematics. I am just trying to tell you the importance of intellectual property rights, why we are so concerned about these rights. It has become now the business gimmicks. You have to know, you have to have the information about why it is so important. Then you will think on it. Then you will invest your time, your energy, your manpower in developing these intellectual property rights. मेरा काम आपको सेंसिटाइज करना, एक्सपर्ट बनाना नहीं है। एक्सपर्ट तो अभी अटॉर्नी थे ही, आप उनसे फीस ले लीजिए, दे दीजिए, वो आपका टाइप कर देंगे। बट हु विल क्रिएट इट? दे आर द अटॉर्नीज। बट हु इज द क्रिएटर, हु इज द इन्वेंटर, हु इज द ऑथर? यू। थोड़ा कुछ इंटरेस्ट आ रहा है? मैं देख रहा था लोग पीछे सो रहे थे, कुछ लोग आपस में बातें करने में मस्त थे, कुछ ट्यूटर बोल रहा है। हम लोग भी ऐसे ही थे पहले, जब स्टूडेंट थे तो ऐसे ही सुनते थे। अरे एक ही प्रॉब्लम होती थी, एग्जाम आ जाता था, वरना लाइफ बिल्कुल कूल। मैं फिर एक चीज कहता हूँ हमेशा अपने लोगों से, जो क्लास में बैठना is the golden period of your life. No tension. अब बता रहा हूं, जिसने जो डिग्री, हाईएस्ट डिग्री क्लास अटेंड किया है, वही उसकी लाइफ का गोल्डन पीरियड है। जिसने बीएससी के बाद जॉब शुरू कर दिया, वो बीएससी याद करता है। जिसने एमएससी के बाद किया, वो एमएससी। मैंने एलएलएम कर लिया वाइपो से, तो वो मेरा गोल्डन पीरियड था 2006-07। एमएससी के बाद क्लास अटेंड वही करी थी। चलो खैर, coming back to IPR, I have so many stories. I can keep on speaking, telling you the stories. अब हम लोग पहले बात करते हैं पेटेंट की, जो आप लोग ये स्लाइड पे आ जाइए। फर्स्ट 3 तरह के पेटेंट होते हैं, तीनों में कौन सा सबसे इंपॉर्टेंट है, कोई बता पाएगा? कोई आइडिया? क्रॉस टॉक्स नहीं, जो होगा मुझसे बात करेगा, आपस में बात करेगा तो गड़बड़ हो जाएगा। विच इज द मोस्ट इंपॉर्टेंट पेटेंट है? प्रोडक्ट पेटेंट, someone said patent. Why? Yes, this is true.
By patenting the product, we automatically patent the product.
We can have process patent also. There is no product. A process to manufacture paracetamol is a patent.
But by reverse engineering, we can modify and modify.
Oh, wow, good, excellent. But chalo. Good, this is right. The product patent is the most important and most strongest patent. क्यों प्रोडक्ट पेटेंट इंपॉर्टेंट है? क्योंकि आप जो भी वैल्यू देते हैं, कॉमर्शियल वैल्यू प्रोडक्ट की होती है। मुझको फार्मास्यूटिकल मैन्युफैक्चरिंग पैरासेटामोल बनाने में कितने पैसे खर्च हुए उससे कोई लेना देना नहीं है। मुझको पैरासेटामोल टैबलेट कितने की मिल रही है, मैं उसका पे कर रहा हूं। किसी भी हम प्रोडक्ट खरीद रहे हैं जिसका हम पे कर रहे हैं, तो इंपॉर्टेंट सबसे वैल्यूएबल कौन सा है? प्रोडक्ट पेटेंट। in India, we didn't have product patent regime. हम लोग प्रोडक्ट पेटेंट नहीं देती थी इंडियन गवर्नमेंट। तब हम लोग जो पेटेंट अटॉर्नी, यू कैन से पेटेंट एक्सपर्ट्स, what we were doing, we were trying to protect the product, like say process patent होता था इंडिया में, तो what we were doing, a process to manufacture this thing and the product thereof. We were trying to cover the product, क्योंकि वैल्यू कौन देगा? सिर्फ प्रोडक्ट। इसलिए प्रोडक्ट को कवर करना आपके पेटेंट में जरूरी है। उसके बाद हम लोग आते हैं बहुत इंपॉर्टेंट, कॉपीराइट। मेरे ख्याल से एक सेशन कॉपीराइट पे हो चुका है। सिर्फ मैं एक स्टोरी बताता हूं कि शेक्सपियर ने पहली बार रोमियो जूलियट की स्टोरी लिखी, उसके बाद 1000 बार रोमियो जूलियट की स्टोरी लिखी जा चुकी है। ठीक, मैंने वो सारी 1000 जितनी लिखी थी, सारी नॉवल, सारी स्टोरी, सारी स्क्रिप्ट, सारी बुक्स सब पढ़ ली, और मैंने अपनी एक नई स्टोरी लिखी जिसमें कोई भी पैराग्राफ, कोई भी सेंटेंस किसी एग्जिस्टिंग कॉपीराइट से कॉपी किया हुआ नहीं है, प्लेगरिज्म का केस नहीं है। तो नई स्टोरी जो होगी वो मेरा कॉपीराइट होगा। Getting the point? The way of expression is new, is novel, has not been copied from any document, any prior document. So the new version will be my copyright. एक इंटरेस्टिंग स्टोरी बताता हूं। आप लोग किसी रेस्टोरेंट में जाते हैं डिनर करने, किसी अच्छे रेस्टोरेंट में जाइए, एक आदमी बैठा गाना गा रहा है, पता है वो उसने परमिशन ले रखी है कॉपीराइट ओनर से, वो यूं ही नहीं गा रहा है। आप लोगों ने बहुत लाइटली ले लिया, जाके कहें सर ये वाला गा दीजिए। अगर उसने परमिशन नहीं ली होगी तो वो कॉमर्शियल एक्टिविटी नहीं कर सकता। जैसे गाना.com है, गाना.com में सारे गाने फ्री हैं, हम जितनी बार चाहे सुने, हमें कोई पेमेंट नहीं करना। लेकिन अगर गाना.com से डाउनलोड करके हम कोई डीवीडी बना दें, कोई डेटाबेस बना दें, कोई चीज कर दें जिसकी वजह से हम कॉमर्शियल एक्टिविटी करने लगें, तो गाना.com हमारे अगेंस्ट केस फाइल कर देगा। उसने वो सब फ्री रखा है हमारे पर्सनल यूज के लिए। वी कैन यूज इट फॉर आवर पर्सनल पर्पसेस। We cannot do any commercial activity out of it. समझे बात? मतलब ये जो मेरा प्रेजेंटेशन है, जैसा अभी उन्होंने बताया भी था, ये मेरा कॉपीराइट है। बिना मुझसे पूछे अगर आपने कहीं पे दिखाया, किसी ने फोटो खींच ली और कहीं दिखाया, तो मैं केस कर सकता हूं। क्या telling illegal, which is not authorized. This is an educational purpose event. It should be. People should know it. Even it is live. They cannot do the commercial activity out of it. If they are using for their learning, their understanding of the topic, good. Let them do it. This is the purpose. But they cannot do any commercial activity out of it. तो मैं आपको बता रहा था कि जो आप रेस्टोरेंट में गए, जो गाना गा रहा है, उसने कॉपीराइट ऑथर से परमिशन ले रखी है। कॉपीराइट की लाइफ क्या होती है, किसी को पता है? व्हाट इज द लाइफ ऑफ अ कॉपीराइट? लाइफ ऑफ ऑथर, हाँ सर ने बिल्कुल सही बताया, लाइफ ऑफ ऑथर प्लस 60 ईयर। अब जो मुकेश जो गाने गाए तो चल, अब नील नितिन मुकेश के पास वो सारे कॉपीराइट हैं। आज की तारीख अगर मुकेश के गाने गाए जाएंगे तो एक पिक्चर बनी, किसकी ओनरशिप होगी? पिक्चर बनी, किसकी ओनरशिप होगी? मेरा फोन बज रहा है क्या? बज रहा है? हाँ, किस हो गया? अरे हमें बताओ, हम भी खुश हो थोड़ा। तो आपस में बात नहीं, बात सिर्फ हमारे साथ, ठीक है? क्या बताऊंगा पता नहीं। उसके बाद लोग ट्रेडमार्क को बता दिया, क्या वैल्यूज? बिलियन डॉलर्स। क्यों? क्या हम नाइकी, एक टिक मार्क है नाइकी का, क्या हम उसे यूज कर सकते हैं? क्यों? क्योंकि वो प्रोटेक्टेड है। बहुत एक लखनऊ के, हम लोग लखनऊ की स्टोरी बता, टुंडे कबाबी आपने सुना होगा, उसका ट्रेडमार्क डिस्प्यूट सुप्रीम कोर्ट में जाकर सेटल हुआ। सुप्रीम कोर्ट की फीस मालूम है वैसे कितनी होती? किसी लॉ, यहाँ लॉ के भी कुछ स्टूडेंट और फैकल्टी में देखे आते हैं, एक लॉयर्स कपिल सिब्बल साहब 15 लाख रुपए लेते हैं सुनने के, उसके ले ना ले उनकी मन। अभी फिर ये लाइव है, देता हूँ। जब धीरू भाई अंबानी आपके जाने के बाद अनिल अंबानी, मुकेश अंबानी में डिस्प्यूट हुआ, तो 87,000 करोड़ की प्रॉपर्टी थी, 40,000 करोड़ प्यार से बढ़ गए, 7,000 का डिस्प्यूट पहुंचा। एक पार्टी के लॉयर थे राम जेठमलानी, एक पार्टी के लॉयर थे कपिल सिब्बल। मैंने पेपर न्यूज में पढ़ी है, टाइम्स ऑफ इंडिया में, वही बता रहा हूँ। 2 साल के बाद लॉयर्स का बिल था 600 करोड़। क्या कर रहे हैं आप लोग यहाँ पे बैठ के? लॉ फैकल्टी कहाँ है? लॉ वाले कितने बच्चे हैं यहाँ पे सर? तो 600 करोड़ लॉयर्स की, ओ गॉड। चलिए खैर, वापस अपनी फील्ड में। ट्रेडमार्क आप सब लोग जानते हैं, हर तरह की चीजें। उसके बाद जियोग्राफिकल इंडिकेशंस। जियोग्राफिकल इंडिकेशंस क्या होते हैं, कोई बताएगा? लखनऊ का लखनवी चिकन, बनारसी साड़ी, आगरा का पेठा, भदोही का हैंडीक्राफ्ट, ये सारी चीजें जो ज्योग्राफिकल एरिया से कंसर्न है, वो जीआई में रजिस्टर्ड होती हैं। कैसे होती हैं पता है? हमारे पास आइएगा अगर किसी को करानी होगी तो। नेक्स्ट जो सर ने सवाल पूछा था डिजाइन, सर सॉरी मैं आपका सवाल ठीक से समझ नहीं पाया। जो मैं समझ पाया, किसी भी चीज का, किसी भी आइटम का, किसी भी प्रोडक्ट का एस्थेटिक व्यू जो आप देख पा रहे, वो डिजाइन प्रोटेक्शन में प्रोटेक्ट होता है। पहले 5 साल के लिए रजिस्ट्रेशन होता है, 2 बार रिन्यू कर सकते हैं, तो मैक्सिमम 15 साल के लिए होता है। ये करते हैं कौन? रितु बेरी ड्रेस डिजाइनर या तनिष्क, वो अपने निकालता है ताकि लोकल ज्वेलर्स उसको कॉपी न कर पाए। और इतनी तेजी से डिजाइन बदलते हैं कि 15 साल तो बहुत ज्यादा होते हैं, 5-7 साल से ज्यादा कोई रजिस्ट्रेशन रखता नहीं है, तब तक नए डिजाइन आ जाते हैं। इन डिजाइन की वो वैल्यू है सर, जो जितना मैं समझ पाया, आपके जितने पैटर्न हो, चाहे आपने कंप्यूटर से बनाए हो, चाहे किसी डिवाइस से बनाए हो, चाहे हैंडमेड बनाए हो, आपको सारे के सारे पैटर्न एक सीरीज से डिजाइन प्रोटेक्शन में डालने पड़ेंगे, वो डिजाइन में प्रोटेक्ट हो जाएंगे। ये वैल्यू है डिजाइन की। कोका कोला की बोतल का कोई कॉपी नहीं कर सकता, ठीक। मेरा ये पार्कर का पेन है, इसका डिजाइन कोई कॉपी नहीं कर सकता। अब मैंने क्यों पेन निकाल लिया तो इसमें बता दूं, इसमें इस पेन में जरूरत पड़ती है, मैं जस्ट आइडिया देना चाहता हूं। या ये पेन ड्राइव है, या ये माइक है, या कोई भी सिस्टम, हमारा मोबाइल है, मोबाइल में कितने कितने आईपी होंगे बता सकते? नहीं, ऑलमोस्ट 200-300। मेरे पेन में भी 3-4 तो पेटेंट होंगे। एक इंक का फॉर्म है, वो तो पेटेंट है। सर ने बताया बिजनेस मॉडल्स। अब एक चीज बताऊं इसी में, यूएस में बिजनेस मॉडल पेटेंटेबल, इंडिया में ट्रेड सीक्रेट में आते। बिजनेस मॉडल जैसे सर ने कहा, मैं एग्जांपल देने की कोशिश कर रहा हूं। जियो मोबाइल एक नई स्कीम लॉन्च करने वाली है। आज अगर 6 फरवरी है तो 1 मार्च को एक नई स्कीम लॉन्च होगी। ये ट्रेड सीक्रेट है, जियो के कुछ ही बॉसेस इसको जानते हैं। ये लीक अगर 28 फरवरी तक लीक हो गया तो एयरटेल और वोडाफोन और ये सब सेम स्कीम लॉन्च कर देंगे उससे एक दिन पहले। तो ये मेन ट्रेड सीक्रेट है। अब सर जैसे आपने कहा बिजनेस मॉडल्स, मैं आपको इसमें एग्जांपल देता हूँ। यूएस में बिजनेस मॉडल पेटेंट होते हैं। कैसे मॉडल पेटेंट होते हैं, हमने भी सोचा, एक बार दिमाग लगाया, थोड़ा पढ़ा तो समझ में आया कि एयरलाइंस वाले आपको नेक्स्ट सिटिंग पर्सन की एक्सपर्टीज का एक ऑफर दे रहे हैं। 100 रुपीज एक्स्ट्रा चार्ज कर रहे हैं, आपसे फॉर्म भरा रहे हैं। आप लोग जैसे हैं, मैं अगर उसमें बैठा, मैं आईपी का लेक्चर लेने जा, आईपी का प्रोफेसर मिल जाए, लॉक हाउस से 2-4 बातें कर लूं। कोई आदमी प्रॉपर्टी डीलिंग में है तो वो सोच रहा है कोई बिजनेसमैन बगल में मिल जाए, उससे ये कर रहे। और उन्होंने देखा कितने लाखों लोग पर डे फ्लाइट ले रहे हैं और 100 रुपीज चार्ज कर रहे हैं। आपके नेक्स्ट सीट में जो पैसेंजर है वो आपके इंटरेस्ट का है, ताकि आप अपना 1.5-2 घंटा जो पास कर रहे हैं उसके साथ कुछ फ्रूटफुल डिस्कशन कर पा रहे हैं। आइडिया अच्छा है कि नहीं? 100 रुपीज। अरे आजकल तो कुंभ के चक्कर में इतना फेयर हाइक हो गया है कि लोग जा ही नहीं पा रहे। 100 रुपीज एक्स्ट्रा, और उसकी वजह से वो पेटेंट है, उसे कोई कॉपी नहीं कर सकता। इसमें फिर वही बात, एक मैं नाम नहीं लूंगा, बिजनेसमैन ऑनलाइन हूं, एक बिजनेसमैन को फाइनेंस मिनिस्टर से मिलना था, उस वक्त चिदम्बरम साहब फाइनेंस मिनिस्टर। बहुत दिन से कोशिश कर रहा था कि साहब आधे, जैसे जैसे होता है ना इंश्योरेंस एजेंट, अगर आपसे मिल जाए और आधे घंटे आप उसकी बात सुन लें तो मना करना बहुत मुश्किल है। वो ऐसी चीजें आपको समझा देगा कि साहब इसके बना तो आप मतलब बेकार है जिंदा रहना, है ना। उसका तो रोल ही यही है, उसकी ट्रेनिंग यही है। तो वो बिजनेसमैन बड़ी दिनों से कोशिश कर रहे थे फाइनेंस मिनिस्टर से मिलने की। उन्हें पता चला कि फाइनेंस मिनिस्टर दिल्ली से चेन्नई की फ्लाइट पकड़ने वाले। फाइनेंस मिनिस्टर लोग हमेशा, ये जितने डिग्नेटरीज हैं, ये फर्स्ट सी या फर्स्ट डी सीट पे ही बैठते हैं बिजनेस क्लास में। तो उन्होंने फर्स्ट बी किसी को दी नहीं जाती जब तक पूरी ऑक्यूपाई न हो जाए। उसने कहा मुझे फर्स्ट ए दे दीजिए। उसने अपने एजेंट से कह के फर्स्ट ए बुक करा ली। फर्स्ट बी पे कोई नहीं था, बस फर्स्ट सी पे फाइनेंस मिनिस्टर बैठे थे। 2 घंटे के बाद उसने जो समझाया, उसने कहा मेरा काम हो गया। दिस इज अ बिजनेस मॉडल। ये ट्रेड सीक्रेट। अच्छा खैर, वापस बेस्ट एग्जांपल ट्रेड सीक्रेट का है फॉर्मूला ऑफ कोका कोला। कोका कोला कितने साल पहले बना था, किसी को आइडिया है? करीब 150 साल पहले, 1880, 1882 या 1884 के आसपास ये कोका कोला मार्केट में आया था। आज तक उसका फॉर्मूला ट्रेड सीक्रेट है, किसी को पता नहीं। अगर वो, अब नाउ क्वेश्चन कम्स, इंपॉर्टेंट, माइंड इट, इफ कोका कोला वुड हैव गॉन फॉर अ पेटेंट 1880 के बाद, समझ लीजिए 50 साल बाद, 60 साल बाद, 100 साल बाद भी अगर वो पेटेंट फाइल कर लेता तो क्या होता? 20 साल में पेटेंट एक्सपायर हो जाता। तो हमारे पास कोका कोला फॉर्मूला की रेसिपी पूरी होती। अब जैसे केएफसी ने अपनी रेसिपी प्रोटेक्ट कर रखी है, पेटेंट है उसकी। 20 साल बाद उसको नई रेसिपी बनानी पड़ेगी अगर उसे बिजनेस में रहना है। तो ये एक, फिर कैसे बताऊं, ये एक बिजनेस गिमिक्स हैं। जब तक मेरा पेटेंट एक्सपायर होगा उससे पहले मुझको, जैसे होता है ना, मारुति नए नए मॉडल लॉन्च करती रहती है। क्यों? अरे अच्छा भला चल रहा है, इंजन वही है, क्यों लॉन्च करती? जैसे ही उसको लगता है ये सैचुरेशन पे आ गया, टॉप पे चल रहा है इस वक्त मॉडल, उसके आसपास ही वो एक नया मॉडल उसी से रिलेटेड एक और लॉन्च कर देते ताकि ये ग्रो करेगा। वो हर एक का लाइफ साइकिल कहते हैं ना, प्रोडक्ट लाइफ साइकिल, मैनेजमेंट वाले लोग जानते होंगे क्या, वो 4 पीस है। कोई मैनेजमेंट वाला नहीं, 4 पीस कहते है कोई? बताइए व्हाट इज 4P? हाँ, प्रमोशन। आप उसको प्रमोशन कर दें, आप प्रमोट करते जाते हैं प्रोडक्ट एक अपने ऑप्टिमल, हर एक चीज की एक लाइफ है, ऑप्टिमल लाइफ। उसके बाद उसका डिक्रीज ग्राफ शुरू हो जाता है सेल। उससे पहले जो डिक्रीज होगा, उससे पहले एक नया मॉडल लॉन्च हो चुका होगा जो अपने पीक पे 3 साल में, अगर मेरी लाइफ साइकिल 6 साल की है तो हर दूसरे साल में एक चालू करूंगा जो अगले 2 साल में पीक पे पहुंच जाएगा। ये मार्केटिंग स्ट्रेटेजी है। अच्छा, ये नथिंग टू डू विद द आईपी। ये मैं थोड़ा अलग चला गया, सॉरी। कमिंग बैक टू माय टॉपिक, अगर कोका कोला पेटेंट पे गया होता तो क्या होता? लास्ट सवाल, अगर आपके पास कोई इंटेलेक्चुअल इनपुट है, उसको पेटेंट पे जाना चाहिए कि ट्रेड सीक्रेट? ओपन एंडेड सवाल, सोचिए, जवाब दीजिए। और इसके बाद मेरी लास्ट स्लाइड, ऑल द बेस्ट, बी हैप्पी। कोई प्रॉब्लम हो, मेरा ईमेल एड्रेस लिखा हुआ है, इसको नोट कर लीजिए। कभी भी पेटेंट से रिलेटेड कोई बात करनी होगी, आई वुड बी मोर देन हैप्पी टू हेल्प यू। मैंने मेरे ख्याल से टाइम पे खत्म कर दिया। थैंक यू वेरी मच। मैंने सोचा ज़्यादा लोगों को बोरिंग ना बनाऊं। कोई सवाल होगा तो टाइम तो होगा।
We can take 2 or 3, quick questions if you have.
अभी किसी के पास क्वेश्चन बचा कि एनर्जी खत्म? बहुत टाइम हो गया, 5:30 होने वाला है, काम करना।
Another way, sir has already given his email ID, so anytime you can write him and then ask him if you have any query. Or we'll call him again on somewhere someday. Okay.
Indeed, you are a treasure trove of knowledge, sir. It was our privilege to have you, and you filled this room with an air of enthusiasm, and I think everyone present here will agree with me. I now request Honorable Dr. Jawahar, sir, to please come and felicitate our dignitary.
Oh. Thank you, sir.
This is for you.
Oh, thank you. Thank you, sir. आज की तारीख में आप हो या ना हो, फोटो होना ज्यादा इम्पोर्टेंट है। अगर फोटो नहीं है तो आप नहीं। ऑनलाइन चल रहा है सर, थैंक यू वेरी मच। अरे बाप,
आप लोग बस मुझे सीधा ही वो करके और लास्ट में मुझे वोट ऑफ थैंक्स के लिए बुला लेना। और सर्टिफिकेट डिस्ट्रीब्यूशन से पहले अगर इन लोगों को वो है ना कुछ वो करना है, किसी को कुछ बोलना है वर्कशॉप किसी का, वो राइट नो फीडबैक कि प्रोग्राम कैसा था, उसके लिए कुछ बोलना चाहता है। हाँ, फीडबैक की कैसा था उसको इन्वाइट कर लीजिएगा एंड देन मैं फॉर्मल वोट ऑफ थैंक्स कर देता हूँ। Okay, so you all are happy. I know your certificate is ready and is with me. It's all ready. Don't worry about it. And tea is on the way. I think it's already arrived. Tea already arrived. So no worry. Formally, I want to give vote of thanks to all of you. First, UPCST for the funding. Our invited speakers to readily agreed, our invitations and the visitors beside their busy schedules, and all the participants to show very high enthusiasm to join us. In just 5 days we received almost 300 registration without any advertisement. And last I would like to thank station to provide us all kind of support, organizing committee members for their support and help. And last but not least, the help from the computer center, Raj Shree ma'am and Jairam from engineering sections. They also need a big thanks because they are taking care all of our technical work. And some of the MSc volunteers in yesterday evening, they worked very hard, like in preparing this selfie point and this IPR Rangoli. So I want to thank them also. And Yes. One more important thing. You have in your folder one feedback form. Everyone has the feedback. So you just fill it down in a 5 or 10 minutes. 5 minutes, you just fill it down and you submit this feedback form here. Okay. This feedback form is very necessary. I need to submit that feedback form to the UPCST. It's very necessary for us. So you fill it down and then submit it. During the tea time, you can also fill, no problem. Don't be in hurry. Take your time. I'll just hand over to Sanjana and Nanya.
With these 5 illuminating sessions, each headed by remarkable dignitaries, we are heading forward to the interaction session. You all have been given a feedback form where you are filling it. But we will like to heartily welcome anyone from the audience if they want to share or give their feedback regarding the workshop. We heartily welcome you. Do we have anyone here?
If you don't give any feedback on here, then program is failed. So give your true feedback here, whether you got the on-time food or not, or whatever your feedback is there, so we can improve on, from here. Anyone can come here. Only 2 minutes. Within 2 minutes, you come here and share your views.
A very good evening to all of you, respected teachers and colleagues. Myself, Rajinikanth Shukla, I'm a research scholar from Department of IT under the supervision of Dr. Raj Shree ma'am. Since morning, I'm just, present in this valuable workshop, that is IPR, which is very, very remarkable for us, that belongs to the information technology and computer science background. So how we can utilize this information and how we can prevent the information slightly the difference which we are getting the confusion about the patent. Sir has given a very slight difference between the type of patent and trade secret and all the things. So this was very, very informative, and that is the kind of giving the new direction regarding the IPR, intellectual property rights. So hopefully this such kind of workshop keep conducting by the Jawahar Lal sir. So please, thank you so much, and this is a very, very valuable for us. Thank you.
Thank you, sir, for the feedback. It will really help us to improve further on.
Thank you so much, respected sir, ma'am, and everyone for today. Now we are reached at the last stage of workshop, distribution of certificate ceremony. I requested to invite Honorable Dr. Hon'ble sir for distribution certificate.
इनके बाद 10 सर्टिफिकेट हो जाए, 10 के बाद राजश्री मैम आ जाएंगे, डॉक्टर अनीश आ जाएंगे, सिलेक्शन आ जाएंगे, 15-20 सर्टिफिकेट हो जाएंगे। ये तो हम लोग 160 सर्टिफिकेट देते थक जाएंगे।
I call out each student, please come on stage.
स्टूडेंट्स नहीं, प्रोफेसर से हैं।
प्रोफेसर सर प्रोफेसर को
स्टूडेंट सीरियल वाइज जो अवेलेबल होंगे उनको दे देंगे, नहीं होंगे एक तरफ रख दीजिए, दे विल कलेक्ट मी फ्रॉम यस्टरडे।
ओके सर।
अच्छा बेटा, आप लोगों का कोई लोग अगर एब्सेंट है जिन्होंने रजिस्ट्रेशन किया है मॉर्निंग में, वो लोग अपना सर्टिफिकेट कल मेरे से ले सकते हैं, मेरे ऑफिस से। नो वरी, जो लोग यहाँ प्रेजेंट है वो कलेक्ट कर लीजिएगा।
The first is Miss Neha Misra. उजाला अभिनव भरनवाल, शशांक शेखर भोई, रितिका कुमारी, नितिन पांडे, सत्येंद्र कुमार, Sakshi Srivast, Saurabh Misra, Anupama Mishra, Upasna Shukla,
ये नाम फिर से repeat
Satyendra Kumar, Upasna Shukla,
We have Assistant Director R&D Cell also, Dr. Jeevan. Welcome him.
Ishita Barnwal, Rajkumar Meena, Sabri Alam Hussain,
रुको इसका तो बोलना फिर से
Asmit Patel, वैभव तिवारी, दिग्विजय सिंह, सान्या चौहान, नीलेश कुमार गौतम, चंदना हजारिका, सारिम अतीक फातमी, समीक्षा राय, पूजा यादव,
सारे नाम हैं सारे
विनय आनंद,
समीक्षा
मिस नेहा भारती,
से बुलाना
संजना, कुमारी रुचि सिंह, हेमा शुक्ला, निर्जला कुमारी,
रुचि सिंह बोलो
सौम्या पांडे, I requested to invite Anish sir for distribution certificates. ममता कुमारी, निगर परवीन सिद्दीकी, निगर प्रवीण सिद्दीकी, निशा कुमारी अग्रवाल, निशा कुमारी अग्रवाल, हिमांशु त्रिवेदी, अंशु कुमार, वेद प्रकाश, भूमिजा पांडे, चित्रांशु भास्कर, सौरभी, अनुशिखा धार दुबे, अभिषेक ठाकुर,
हाँ ये रहा अभिषेक,
चंद्रनाथ हंसदा, विजय कुमार, चंदन शर्मा, सृष्टि त्रिवेदी, नीरज कुमार प्रजापति, नितिका, यश प्रिया वाजपेयी, मौसम वर्मा,
हाँ ये रहा मौसम,
अदिति खरवार, अर्चित पाठक,
ये तो अर्चित पाठक,
हृदोई प्राण शर्मा,
और सर्टिफिकेट कहाँ है? ये एक्स्ट्रा
ज्योति स्मिता धूरे, प्राप्ति साहू, अनित पोल, शिल्पा नेम, अर्जुन सिंह कौशिक, प्रिया तिवारी, अर्जुन सिंह कौशिक, प्रिया तिवारी,
ये रहा शिल्पा,
अंशिका शर्मा,
प्रिया तिवारी,
अनुजिया दीक्षित,
अर्जुन सिंह कौशिक,
प्रिया तिवारी,
उत्पाल प्रताप सिंह, सत्यव्रत मलिक, कृतिका कनौजिया, निकिता यादव, Now I invited to Honorable Dr. Sally Sir for distribution certificates.
निकिता यादव,
Miss Meenakshi Jeff, Miss Kumari Neha, अभय प्रताप वर्मा,
मीनाक्षी
सचिन बोरी, कृष्णा महादेशिया, मधेशिया, सुकृति पाठक, अर्चना चौरसिया, सुकन्या यादव,
कृष्णा मधेसिया,
राशि यादव, मधुरिमा रॉय,
इसका नाम है, वो जल्दी कम फॉरवर्ड। नाम बताओ। सुकृति पाटिल, अर्चना, राजश्री यादव,
हर्ष कुमार गौतम,
राशि यादव,
दिव्यांशी गौतम, सोमा सरकार,
We request no one to leave the auditorium. Please be seated at your places. We will have a group photo after the distribution of certificates. Please have some patience.
जितेंद्र कुमार, अदिति आर्या,
जितेंद्र कुमार,
सुप्रिया कुमारी, अभिषेक कुमार, कुमारी मिर्जा साना बैग,
सुप्रिया कुमारी, सुप्रिया कुमारी, सुप्रिया कुमारी,
दीपांशी सिंह, संगीता मिश्रा, रचना चौधरी, प्रतीक्षा नायक,
रचना, 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 रचना,
प्रतीक्षा नायक, अन्नपूर्णा पांडे, आशीर्वाद द्विवेदी,
संगीता मिश्रा, अन्नपूर्णा, एक मिनट, अन्नपूर्णा, अन्नपूर्णा,
शिवम भार्गव,
प्रतीक्षा नायक, प्रतीक्षा नायक,
आकांक्षा वर्मा,
अभिषेक ठाकुर,
सनकार बैरागई,
आकांक्षा वर्मा,
आकाश सिंह, ओके, देशराज दीपक कपूर, और सर्टिफिकेट कहाँ है वहाँ?
शंकर भाई कुछ नाम रखे,
सोनम कुमारी, मिस मोनालिसा शिवम, इसरा अमन अजीज,
सोनम कुमारी, रामा,
युक्ता सिंह, समर्पिता बैग,
युक्ता, युक्ता, युक्ता,
आकांक्षा वर्मा,
समर्पिता,
शिप्रा पटेल, सत्येंद्र कुमार, नितिन पांडे, अस्मित पटेल, साक्षी शर्मा, निष्ठा अग्रवाल,
छोड़ो इनको साइड रख दो, है ही नहीं।
साक्षी शर्मा,
Now invited to Honorable Dr. Jyoti Pandey ma'am and Raj Shree ma'am for distribution certificates. Mamta Kumari, Kuldeep Kumar Tripathi, Vaibhavi Mishra, Adarsh Pratap Singh, Basila Kashung, Basilia Kashung, sorry to pronounce it. Okay. Haripriya Bora, Sankar Bergai, Akash Singh, Anurag Kumar, Neha Bharti, Shweta Singh Yadav, Anupriya Singh, Saurabh Das, है तो हो गए
नाम आया है क्या नाम है श्वेता श्वेता
शिवम यादव, सौरभ कुमार,
रिपीट करो
नाम बताओ शिवम यादव डन ना रेस्ट को हम लोग ऐसे
रेस्ट मेरा तो है नहीं
लिखा दे सर रेस्ट को हम बोल दिया
नाम एक बार अश्विका शुक्ला पर ले
एक लिख लीजिए बेटा। आप लोग जिनका रजिस्ट्रेशन है
अश्विका शुक्ला
और सर्टिफिकेट आप मेरे ऑफिस से डिपार्टमेंट ऑफ केमिस्ट्री में कल ले सकते हैं, फ्राइडे मंडे ले सकते हैं। मैं यही हूँ, आप लोग भी यहीं के स्टूडेंट हैं। आप मेरे से कभी भी विद इन ए वीक विद इन ए मंथ ले लीजिए। आई हैव अ ब्लैंक सर्टिफिकेट ऑलरेडी साइंड है। आप लोग का बस मैं रजिस्ट्रेशन देख लूंगा कि आप लोगों ने गूगल फॉर्म पर रखा, मैं साइन करके दे दूंगा। नीड नॉट टू बी वरीड अबाउट दिस सर्टिफिकेट, इट्स माय रिस्पांसिबिलिटी टू गिव यू। ओके, जिनका अभी नाम है वो करा लीजिए, नहीं है मेरी जिम्मेदारी आप लोगों को देना। आप मेरे ऑफिस से कलेक्ट करिएगा।
अश्वनी शुक्ला, अश्वन श्रेया दुबे, धनाशरी गिरधर खोलेकर, धनाशरी गिरधर खोलेकर, ये धनाशरी दिव्यानी कोशला, हिमांशु केशारवनी, संजना सिंह,
हिमांशु केसरवानी आगे बढ़ो हिमांशु केसरवानी नाम बताओ। संजना सिंह
बस हो गए।
दे दो संजना सिंह।
पल्लवी सिंह, अमिता सिंह, प्रगति, सत्यम शुक्ला, रितेश पाल, अनुपम लता, सार्थक, बैसीला काशुम, सौरभ कुमार, अस्मित पटेल, नितिन पांडे, सत्येंद्र कुमार, आकांक्षा वर्मा, अनन्या त्रिपाठी, ममता कुमारी, सौरभ दास, आकांक्षा वर्मा, आशीर्वाद द्विवेदी, मेरा मैं प्रेजेंट हूँ। ये कोई बात है? तू फोटो लेकर के ये फोटो ले ले, मेरा तो नाम ही नहीं है, मैं कैसे फोटो ले? जाओ दूसरे वाले नाम हो जाए तभी अब हो गया सर, कितना लगा? बस तो अब ये वाला
ये चल रहा है जयराम, चल रहा है नहीं अभी नहीं चल रहा है, अब चलेगा। ओके, यू प्लीज सिट डाउन। स्टूडेंट्स आप लोग प्लीज बैठिए, ग्रुप फोटो होना है, उसके बाद हम लोग टी सर्व करेंगे। एंड जिन लोगों को नहीं मिला दे विल कलेक्ट फ्रॉम मी, नो प्रॉब्लम। चल जाएगा। Okay, we also, as an organizing committee member, we also need appreciation. Okay. so I just request Dr. Kulbe sir. Dr. Kulbe sir. Okay. ठीक है बेटा, सर को और बुलाएंगे हम लोग अभी। So I request Kulbe sir to give a memento to Dr. Raj as an organizing committee member. Raj Shree ma'am, you know, take care all of this online broadcast business. Madam needs a big round of applause. Thank you, Raj Shree ma'am. And now I request Dr. Ahmad sir. Bilkul. Sir also need a very big round of applause. और एक शायरी और सुनेंगे सर आपसे, बाद में एक शायरी, उसके बाद प्रोग्राम एंड होगा, तो सोच लीजिएगा आप अच्छी शायरी। एंड now I request we have a assistant director R&D Dr. Jeevan also. So in our file processing help a lot to get this fund. So I just give him a flower pot with for his office. Just come here, sir. Thank you, Dr. Jeevan, for assisting in different ways. And I think is all. And for group photo, I request all of you to, come here. Gather here around us.
Organizing members को पहले बुला लो, सीट बचेगी तो और भी faculties को बुला लो.
So I request all the organizing committee member, Dr. Kulbe, Dr. Anish, Dr. Jeevan. Okay. Okay, sure. ये आपके पास है, ले लो. Ravi sir, your certificate is with me, and Dr. Kulbe will give you the certificate. Okay, so we have Dr. Ravi from Department of Microbiology, and sir certificate with me. Sir is giving his blessing from the morning to us. Very early he came to me. Thank you, sir. अच्छा, and Dr. Rajesh. ज्योति मैम से ले सर. ब्लैंक दो सर्टिफिकेट दीजिए बेटा. नाम हम लिखिए. and Jyoti ma'am please. And this is the last certificate. Madam also need a very big round of applause because yesterday till 8 o'clock she is with us, Dr. Jyoti. Okay, thank you very much, ma'am. मैम आप लोग भी आ जाइए एक साथ जो है. आप सब लोग इधर फ्रंट की तरफ गैदर हो जाइए. ग्रुप फोटो कर लेते हैं, देन हम लोग चाय लेंगे. कैमरा है किसी के पास? नहीं, वो लाइव स्ट्रीमिंग बंद हो जाएगा हमारा. लाइव स्ट्रीमिंग बंद हो जाएगा.
लाइव स्ट्रीमिंग के सामने से हट जाइए प्लीज.
तो बोल रही थी तेरे मजाक कर रहे थे सब. तो मुझे मेरे को नहीं मिला, फिर तूने ऐसे कर दिया तो बोल रहे हैं देखिए तो प्रोसेस कर रही है. अरे मेरा नाम ही नहीं सोच रहा. ये गुस्सा हो रहा है तुम्हारा. इसका टाइटल तुमने गलत प्रोनाउंस किया. आज तक तुमने बताया था. मैंने बोला था मदेशिया. तुमने बोला था. हां, आज कृष्णा बहुत खुश लग रहा है. डेली ऐसे मूड में नहीं रहता है. सब तैयार हो गए. हम भी चल रहे हैं यार. पता चला पार्टी भी है. सचिन आया ही एकदम बंद हो गया. मैं
दीदी नीचे भी है.
May I have your attention, please? We will have a group photo downstairs as well. So I request all of you to patiently be collected there.
बेटा एक ग्रुप फोटो बाहर और होना है. बाहर जो सीडी है ना जहाँ रंगोली बनी हुई है, सब लोग वहां पहुंचिए. उसके बाद आपको हम लोग टी ओपनिंग करेंगे. उसके बाद फिर आप लोग जा सकते हैं. ठीक है, थैंक यू ऑल. बाहर बेटा, बाहर जो ग्रुप फोटो हम सीडी पे करेंगे, वहां पर और आप कुलबे साहब के साथ और आप फोटो ले सकते हैं. अभी सब लोग बाहर सीडी पे जाएंगे ग्रुप फोटो के लिए. शिवम एक किसी लड़के को भेजिए साहब का।
इसको ही सिर्फ ले चलते हैं आगे, मैं समझ में, और एक उसमें बस ग्रुप करके फिर फट से यहाँ पे अभी इधर से तुम्हारा हाथ कैमरे पे आ। ये ठीक है तो मैं बात
Yes.
जवाहर से बाहर आ जाइए सर, आ जाइए सर, अब बाहर आइए सर। इसको दिखाते हैं।
Almost.